All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We're on the record in CV21 0720 Silverman et al. Versus Access. We are going to be recording and live streaming these proceedings, so please announce your name and your client's name when you approach the podium. You'll get 20 minutes per side. You don't have to use it all, and you're required to keep your own time. The clocks are right there for that. And keep in mind as you're arguing that we have read the briefing, studied the record, and conferenced this case before argument. So with that, counsel, you may proceed.
Good morning, Your Honors. May it please the Court. My name is Jacob Carr, here today with my colleague, Greg Leslie, and I'm appearing on behalf of the appellants in this matter, Amy Silverman, Alex DeBoyd, and T&I Partners, doing business as the Arizona Daily Star. I want to start by emphasizing that this appeal is about the discrete question that the court below decided on a motion to dismiss, presuming as true the facts alleged by the plaintiffs, the appellants here. And that question is whether Arizona's public records law requires that in at least some circumstances, when a state agency produces data stored in an electronic database, it must also preserve and produce the links that connect the data within the database so that the data remains connected when produced to the public. If these existing links contain protected information, preserving them in the way that our clients have proposed is just one simple method of obscuring or segregating non-disclosable data from disclosable data already in Access's possession, and thus does not require the creation of a new record. And that's because fundamentally, the creation of a new record occurs when the requested public record does not already exist. As this court put it in ACLU v. DCS, the relevant question is whether the public record exists to be found or it does not. And here we've sufficiently alleged that these links do exist, that they're central to the public records at issue, as they are the connective tissue that holds the data together. Access itself, the appellee here, has suggested that it does use such links, at least in its primary HA plus database at issue here, though there's a separate unanswered factual question as to the extent and nature of those existing links. So appellants should have the opportunity to demonstrate with further factual development, evidence, expert testimony, that preserving these links would require Access to do no more than apply a straightforward query to the data it already possesses, in the same way that searching, sorting, extracting, obscuring, or segregating data in or from a database in its native format requires some sort of basic programming.
But it's a little bit more than sorting. You have to substitute some sort of name or code. You have to some way of encrypting it so you can protect the confidentiality of the name. So it seems a little more than simply sorting.
It's I think, most closely analogous to segregating data, which agencies are required to do. This court has held before, including in ACLU v. DCS, that the segregation of data in order to extract the data from a database does not require the creation of a new record. And
when you mean how is it segregating? Explain that to me.
So the relational links that are at issue here contain both the formal content within those links that Access has represented contains some sort of personally identifying information that's otherwise protected and non-disclosable. But the function of the functional aspect of those links, the fact that they provide information that simply says, like, this is how one piece of datum in a database relates to another piece of datum, that is disclosable information. As this court put it in DCS again, the entire agency database is itself a public record. In DCS, it was the child's database. Here, it's HAA Plus and the two allied databases. Part and parcel of that database are these relational links, the way that the data is connected across the database. And so in that sense, it's segregating the disclosable functional aspect of these relational links from the purportedly non-disclosable content of the
But
links.
can that be provided without any names? I mean, can you get the information that shows the algorithm, for want of a better word, of how things are working without turning over the results, anything that includes names, even with redactions? Is it not sufficient to simply get whatever the algorithm is that's being used?
Well, can we just, because we've been throwing around words that I want to make sure are mean the same thing to both sides, or that we're not misusing them. When I hear the word algorithm, I think of something that is computer-based, that's analyzing information, that it's looking at the information, analyzing it according to whatever parameters someone has programmed that algorithm to run. And so I don't know if algorithm isn't the right word in that scenario. I want to know what is. Because to me, I don't think you're asking for the parameters by which Access evaluates who gets alt text, because that's what your clients are trying to figure out. You're not asking them to give you those parameters. You're asking to look at the data to figure out if you can match things up to who's getting it, who doesn't. Am I right?
Correct. I'd just like to clarify, though, that we're not seeking names. We're not actually at this point seeking that. None of the specific pieces of information that my clients are seeking implicate HIPAA-protected information. My clients are not looking to match up exactly who or individuals who are receiving benefits, but simply looking to study on behalf of the public patterns in how Access allocates or screens applicants for alt text benefits.
But you're not asking for the parameters that Access uses. You're not saying, tell me that tell me the decision tree about how someone comes in and then they go here if they're yes, they go here if they're no, this breaks down even more. You're not asking to see that analysis that Access runs, correct?
Correct.
So, and that to me is what an algorithm is how things are sorted out to decide who gets something.
What we're asking for is in producing the records, for Access to consider, as it must under the public records law, a practical alternative to not disclosing these relational links. And that practical alternative is a simple, and we would like the opportunity to demonstrate past the motion to dismiss stage that simple practical alternative would be a very basic query. In the same way, just to take a concrete example from this case.
But if you're saying I want to show the court how easy it would be, but that's not really our question, is it? Our question is doing that, creating a new document? Is it making them create a new public record? So it could be as easy as anything and still be something that they're having to create. It could be very, very difficult, but still fall into a category where they're not creating a new document. So I'm not sure easy or hard is the analysis here, is it? It's whether they're having to create a new public record in order to satisfy your request.
And so, and just like, for example, Access, our clients have requested date information for specific pieces of information with respect to date, which Access has said it could provide, but it would need to obscure all more specific elements of those dates except for the year. In order to do that, in order to extract just the year from those date fields, Access would need to run a very simple query in order to extract just the year from those fields. That Access does not argue, and this court has previously held, is not the creation of a new document or a new record.
It's segregating. Based on year.
Exactly.
Okay.
And it's that exact same type of simple programming that we allege would be required in order to take the full relational links and input a very simple query to hash them or otherwise mask or obscure them.
Let me just kind of tease out. So the algorithm is the program that the data goes through, and that's not what you're asking for. Fair statement?
We're not asking for...
But what the algorithm is. The algorithm is what happens, how DCS processes the data.
Correct.
The data that you're looking for are the individual records, and that could be a client file and the documents that were provided as part of that client file, correct?
No, I'd like to clarify. So we're not seeking supporting documents at all. We're only seeking raw data. And if I may, just to explain exactly.
No, that's fine. That's what we want to understand.
The current parameters of the request. Because my clients have significantly tailored their original request based on their own review of the alt text pre-admission screening manual. They narrowed the request to ask for 46 specific pieces of information. After a further negotiation consultation with Access, they removed voluntarily 7 pieces of information.
Right.
And based on Access's, I apologize, Your Honor, based on Access's HIPAA concerns and burden. And so
Go ahead.
no, just to put a fine point on it, Access has previously stated in pre-litigation negotiations that it could provide those pieces of data in tables, each in its own independent table, but unlinked from any other piece of data.
Okay.
And that's what we've asked for, just the tables of data that Access said it could provide, but with preservation of the pre-existing links that connect the data.
Okay.
But you say pre-existing, that's a big word, because you don't, and that's part of what you say is the fact-finding. You don't know that they have, and in fact, isn't there briefing saying, we don't have to link the information the way you want it for us, for these public records to serve us? Why should we have to make sure all of it's linked for your purposes?
Your Honor, I appreciate the opportunity to clarify this point as well, because we believe that Access's briefing here, their argument with respect to the creation of a new record, relies principally on this mistaken assumption that we are requesting new links where there currently are none. Our position is simply that where these links already do exist, as maintained by Access for its own operational needs in the ordinary course of its business, that the public records law requires that they be preserved. Based on my client's long-running negotiations with Access before filing suit, it is our understanding that the data, or at least some of the data, is already linked, and those allegations should be presumed to be true, but you don't need to even take just our word for it. Although Access in its briefing appears to suggest that none of these links exist, or no links exist, the declaration that Access's briefing relies upon, both before this court,
Says that they're not sure.
says that they're not sure.
Right.
And in fact, in paragraph 6 of the declaration, this is appendix page 44,
We've seen it.
Stacey Westerholm states that there are identifiers. It's just that it's possible that not all of the tables use the same identifiers.
So let me ask you this then. Old days, there'd be one file, right? And each person would have one file, and all the papers for that file would be in that person's paper file. Public records law were written for that situation, but nowadays, we've got this database, this database, this database, and pieces link up, satellites connect, or whatever it takes. What you're asking for us is to create what seems to me a new category, and I'm going to call it an encrypted redaction. Would that be a fair statement, where I want you to mask the original date, the original link, so I can't see what's in it, and create a new link or a different link that allows the system to show me where those links are without the identifying information?
I think that is a fair characterization.
And it seems to me that's an encrypted redaction. Old days, we would have just put black lines over everything, but it all would have been in one file. Nowadays, it's not all in one file. So I'm struggling with why that's not the creation of a new record. And I know it doesn't, there's a tension between the way the public records law works and trying to get information, and the way it was written and what it was written for. So help me with why that's not a creation.
Well, I think, Your Honor, the very use of the word redaction in the way that you characterize it, I think it helps to demonstrate that all we're asking for is simply an extension of agencies' obligation to redact and segregate non-disclosable information to electronic storage of data. It's to ensure that the public records law continues to serve its twin goals of government accountability, transparency in the 21st century.
Have we ever done that? Is there any case where we've done it?
No, and as the court below recognized, this is a matter of first impression, I think, in large part because of the technology at issue here. It is new and evolving.
At the federal level, though, haven't they kind of dealt with this issue? I'm thinking the DC case, and I'm sorry, I'm going to stumble on it.
FEC.
Do you know the name? I'm sorry.
Is it the FEC case?
The Center for Public Integrity
Thank you.
versus FCC.
That's the one that I'm thinking of, where they basically said they didn't have to create this.
So
kind of new-
I think the facts of that case are actually just quite distinguishable from the facts here. The requesters were asking the FCC to replace numerical responses that FCC was tracking with statistically analyzed or like manipulated ranges or averages of those responses. In other words, they were asking, even though that may have been, as Judge Bailey stated a few minutes ago, a simple calculation or program, it would have required the FCC to track data that it wasn't otherwise tracking. Here, we're simply asking for access to preserve data and links that it already possesses, and
But to modify them in some way.
only in the production of those records, in the same way that redacting a paper record or redacting an electronic record modifies the actual physical record somehow when it's produced to the public. And
Are you suggesting that they could simply redact, and every time they redact, just substitute, put in some identifier? Is that what your request is, that you've redacted a name and then put N1, and then N1 substitutes everywhere else, but you're not creating anything new other than
it's
you're putting...
essentially that the hash function is itself a form of redaction. Instead of a black marker, it's just this function that redacts the non-disclosable
But it redacts and adds something, but you're saying the addition is simply something that's not complicated, you're not changing
Correct.
anything.
And it may not necessarily, and this is why factual development may be important here, would be important here, is because it may not necessarily add anything. It could be that the unique identifiers that Access asserts are contained in these links could be anonymized or de-identified by a program that simply deletes a number of digits from the identifier. And in that way, you wouldn't necessarily even need to add anything, but you would be de-identifying them in such a way through the use of programming that they're functionally redacted.
But it's linking those redactions. That's really the crux of what Access is saying is making this a new record. It's not going in and saying, I'm going to make it N1, F1, and I'm going to take out a couple numbers in an address. It's relinking all of those pieces of information so that you can follow that N1 lives at this address, applied on this date, and has these infirmities that qualify them for alt text. It's the added linking of those redacted pieces that they're complaining about. Am I right about that? It's
Correct.
not the putting in the identity.
But we're asserting that those links already exist, so they wouldn't need to be added, and it would simply be one query, for example, that could extract all the data that Access has already stated it could provide, and functionally redact or meaningfully redact those links so that the output, the extracted data that is provided to the public, contains all of the data de-identified, but with the links preserved.
So you're suggesting maybe you could just redact every second, third, and fourth letter or whatever. So it ends up with just 5 letters. It's been redacted, but there are enough letters that you can match up. You can use the existing links.
Correct.
So we're not necessarily even adding something. You're just redacting in such a way that it encrypts it.
Correct.
Okay.
And Judge Goss, if I may, just to go back to your analogy to paper files, I think that analogy is actually exactly why we think our position is the one that is the correct position, the only correct position under the Public Records Law. Because in the example of the analog context, in which if Access was keeping all of these records in paper files, they would presumably, for each past pre-admission screening applicant, have a file on that applicant, a folder, that contains all of the information that our clients have requested. And prior to producing those files to us, if our clients had requested them, they couldn't take out or take all of the different pieces of information in an individual applicant's folder and just randomly reassort them into different folders. They would redact the protected information necessary, but then provide us with each applicant's folder with all of the information already linked to that applicant, because it would be in the same folder. And we're simply asking that in this electronic context, that logic be upheld. If the court would permit, I'd like to reserve the remainder of my time.
Certainly. Thank you.
Thank you.
Excuse me. May it please the court. And good morning, Your Honors. Logan Johnston for Access. Your Honors, we are not here today because Access is some rogue agency that doesn't know how or refuses to comply with the public records laws. And we're not here because Access is trying to avoid scrutiny or hide the ball. Access has always been willing to provide its data once it redacts the protected confidential data, which is replete in all its records. The problem is that's not sufficient for the plaintiffs. They want much more. We're here because the plaintiff's complaint demands that Access transform its data and create for them a customized, cross-referenced library of millions of documents for their benefit. This is not a case about segregating or redacting or simply sorting. What I'd like to discuss is what the complaint does ask for and what it would entail and whether the law requires that. The plaintiff's interest is in the long-term care program. There are two components to that, the elderly and physically disabled and the developmentally disabled. There are about 100,000 applications for that program every year. What sort of documents are we talking about? I thought until just now we were also talking about all the supporting documents. The plaintiff's statement of facts in this case says you have to have those documents to make any sense out of the decisions that are made by the pre-admission
Aren't
screening.
supporting documents, aren't they public records as well?
They are, Your Honor. And they are kept in a separate database called DocuWare at Access. And what those records would entail are all the records that you can provide that you think support your application for Altex. All the documents that tend to show that functionally, financially, and medically, your needs are such that you're in immediate need of institutionalization in a nursing facility. So that can be court records, financial records, obviously medical records, anything that you think supports your application, and it can be hundreds of pages for any one applicant. On top of that,
But are you talking about this means it's a burdensome obligation? Are you saying that if they ask for
Well,
it?
we're not at burdensome yet. I mean, let's be clear, we're not at burdensome. So this idea about how many records there are is really not an issue for us as it came up to us, is it? I mean, the court didn't make any determination
I
about
think that's
burdensome.
right, Your Honor.
Okay.
Whether
let's
it's
just-
1,000 documents or 1,000,000
Right.
documents
But-
isn't the issue.
and stipulate to that, but that wasn't a finding that the court made,
Right.
so we're not reviewing it.
Correct. And so I'm merely describing what the process would entail. You've got the HEA Plus computer at Access that has all the data it stores, but you also have all these supporting documents in DocuWare. Those aren't connected. They aren't linked. The document,
If you could clarify for me, and I don't want you to go into great detail, but what is it about the link that is confidential? Because I don't quite understand that. And again, I don't think it's the focus here, but it would help to have that understanding. Why does the link potentially create a confidentiality risk?
I don't know that the link itself does, Your Honor. The link becomes important under HIPAA. If you can link this data and cross-reference it and identify protected information, that becomes a serious problem under HIPAA. But linking the data is not confidential in the terms of the way Access does it. The issue is whether it's linked or not at all.
And so I know we're not here on that issue. We're here on just whether or not the link constitutes creating a new record. But are you saying that if we send this back, one of the issues will be even if you are required to create the new link, it would still involve confidentiality problems?
It would, Your Honor.
So, okay,
Certainly.
I just wanted to understand. So even if we order you to do that here today, it may not happen because the Superior Court's then going to get into the other issues.
That's correct.
Are you
Your-
saying that if you're in the one system looking at it, and someone has applied, and they've got an application, that in order to see their supporting documentations, you have to get out of that area, and that person looking at that data would have to go into a different database because they're not linked? There's not something in the application that just links you up with all of their documentation?
That's correct, Your Honor.
That doesn't exist.
That's
Was that in the record below or in your answer to the complaint?
You know,
You're
what's
saying
in
it
the-
now, but I don't know that it's something that we should even consider if it wasn't.
First, as I say, I think the plaintiffs have acceded to the fact that they need that information to make sense of what they're trying to do. But second, in terms of what's in the record, Your Honor, their complaint attached iterations of their requests to Access. And then in their response to the motion to dismiss, they added the records of our responses to their requests. And in that, there is a December 10th, 2000 letter, I believe. It's at appendix pages 72 through 79. And it goes through their 46 requests one by one. And what it shows is that after you take out 8 requests that HIPAA would not allow, either partially or wholly, and 1 that Access doesn't even track, race, and 3 that would require manipulating data like reducing zip codes to 3 digits, you were left with 34 discrete requests from them, 34 out of the 46. And what we did at that portion of the appendix is go through those requests one by one and show that none of them are linked. None of them. So to give the information that the plaintiffs want is not just our data with existing links from day one. It has been understood by the plaintiffs that that is useless to them. At paragraph 27 of their complaint.
But what if they just say, give us what you have with the existing links and just redact and encrypt? So what's the objection to doing that?
We've been willing to do that, Your Honor. We've been willing to redact our information and give them the raw data.
But with any existing links that are there?
With any, well, that hasn't been the question, Your Honor. I don't know what the existing links are. All I know is that the existing links they want are not there.
But here on a 12b6, it's odd to say there are no existing links. That why isn't the answer we'll turn over whatever we have, whatever existing links we have. We're not going to create any new links for you, but here's what we have. We're encrypting, or we're redacting, encrypting, whatever we're calling it, and do with it what you will, but we're not going to create any new links. Isn't that different than just saying you're not entitled to anything?
Well, sure. And that's why I say, for 2 years we've been telling them we would give them the raw data, but that hasn't been enough. They have told us for 2 years it's got to be linked. And now they're backpedaling saying, well, it must be linked.
Because the way you said that is very different than the answer you gave. So what you're saying is we will give you the raw data with existing links. You're willing to do that?
I'm saying, Your Honor, I don't know what existing links are.
I didn't ask you that. I don't care what they are. I don't care if there's only one. Is your position that you are willing to give them the current raw data together with existing links? Yes or no?
I have to say no, Your Honor, simply because HIPAA would be involved in that analysis. I don't know whether existing links would create a problem under HIPAA.
So why are we here on the 12b6? I mean, that doesn't seem like the right place to be. Because you're saying, I don't know. How do we get to a 12b6 they're entitled to nothing?
Because their complaint says at paragraph 27, Your Honor, it crystallizes the position they've taken for 2 years with us until their reply brief and until this morning's argument. They say at paragraph 27, quote, there is no disagreement over the fact that tables in a relational database that cannot be linked by relational keys are useless. And then their prayer for relief is to order the defendant to immediately provide copies of the requested public records with re-identification hash values to make the data usable. They want us to link the data.
I'm not reading that.
That didn't ask you for new links. So I'm really troubled that we're not quite on the same page. Because the answer is yes, we'll produce it with the links, or the answer that we have, or the answer is no. So your answer to that question is no. So you're not willing to produce the records, all the records.
All I'm saying, Your Honor, is I can't make that statement today because we haven't gotten that far in the analysis.
But you're relying entirely on what you just read, that it's what they're asking for. Because all I heard you say was, what they seem to be asking, to me at least, is we want you to turn over your existing links. It doesn't say create some new ones. We just don't want the data without the existing links.
And the point I was trying to make earlier, Your Honor, is that we've gone through the specific requests they've made, and those 34 items are not linked. They would have to be created, the links for those items of what they've requested. And there's been no dispute about that until lately, that they want that, and without that, the data is useless to them. That's why we're here. Otherwise, we'd have done this.
Because from their perspective, part of your data doesn't get them to where they want to go.
Correct.
They need to have, and that's been their argument all along, is that we either have everything that we're asking for, because that's what we need for our analysis. But getting part of it, even if it's part that has the current links in it, still does nothing for them. There's still something there that they want created. And so while you could have come to an agreement on that, what your point is that that's never been an acceptable compromise, because they need the additional 34 whatever queries made and those links made.
Correct.
Okay.
Where in the record do I find that the 34 things they've requested include no links? I don't know where that is in the record.
It's at Appendix 72 through 79, Your Honor.
And it says for these 34 items, and I'm sorry, I believe there was an affidavit that said that was a little waffly on that issue. But you're saying clearly, these 34, if I look at those exhibits, it says there are absolutely no links among those 34.
That's right.
But what is I was going to ask about the affidavit. If it says, the affidavit seems to indicate, I don't know if these links exist or not.
I think the person who gave the affidavit, Your Honor, was simply talking more generally, not knowing exactly whether they would expand their request. But in detail, with respect to the request they did make, we have answered that. It is in the record. And if I might give you an illustration. Could you give me the numbers
again? I apologize, my
72
computer
to
died.
79.
You've got it? Okay.
It's the appendix to the motion to dismiss, correct?
Pardon?
The appendix to the motion, the
Yeah.
response to the motion to dismiss.
That's correct, Your Honor. If I might give you a simple-minded example. If Access has a table that lists all the Altex recipients by age and another table that lists everybody by gender, you'll have John Doe, an Access member, appear in both those lists, but that doesn't mean those two lists on gender and age have to be related, and they're not. And they certainly aren't related according to John Doe's position in those two lists. So, as I say, I think they are backpedaling from what they've requested.
Well, I just want to understand, because, in the old days, we had a paper file, and all the things were in the file. Something has to link all those pieces together. Because if you don't, you're telling me that you have John Doe, and the only way to figure out how old John Doe is, your person needs to log off of this system, go to this system, and look up the age. And then to do that, then the person needs to log off and go here to find the documents. But that's not the way computer systems work. So there's something that seems to be cross-connecting those. So share with me why I'm misunderstanding that.
You're probably ahead of me in sophistication, Your Honor, but what I think happens is if you're interested in John Doe's age, you go to one table in a database that tells you who's what age in Altex. If you're interested in the gender, you go to a different list. They aren't connected necessarily, and they're not.
So you're saying that your person sitting at the computer
Would go to
sits
two
there and
different
goes,
lists.
John Doe's on the phone, and is called about his file. So they log into John Doe, and all they can see is his name, and to figure out his age, they have to go to a different system, and it doesn't come up in one place? Because that's not ever been my experience with these kind of systems.
Well, let me ask you, there's an application, I assume, they apply, which would have
It has some of the
information on it. And are
information.
you saying that you extract that to make a table? You're saying, we have John Doe's application, he's 59, he's white, he lives in Peoria, he has these maladies that may allow him to enter our program. Are you saying that you take data out of that to make your own tables?
You would take data out of that, and it would appear in tables where you were finding the particular information of interest. You would still have the application somewhere, yes.
Okay.
But what the plaintiffs are asking us to do is create a new set of documents. Take information that's in these documents and remove it. Remove the protected information and replace it with dummy placeholders. And then link all that data together for their...
Does it not work to just delete, keep the first letter, delete 4, keep the next one, delete? Is that different? Is that replacing, or is that just kind of encrypting? So the redaction, you're just not redacting everything, but you're just redacting enough to not identify a particular person.
What the HIPAA process allows, Your Honor, if it allows anything, is to set up a whole new code system whereby you have a specific code for each individual, a specific code for each
So you could go
type of protected
N1,
information.
N2, N3.
Right.
But the redaction's never been your problem.
That's
You will redact, you will replace it with N1 or whatever. It's the linking, right? It's not that you can't make these people anonymous in redaction. It's that the idea that you would have to relink up things you haven't linked. And there's
That-
34 things that you say are laid out in Appendix 72 through 79. And the idea that in this case, they need all 46 requests in order to fulfill what their needs are for this request.
I can't speak to how much of the 46 they need for their purposes.
But that's what their
but that's what
position
they've
has
asked
been.
for. That's correct, Your Honor.
Okay.
And so it's not just redacting, it's replacing one piece of information with another and a code that somehow allows you to put the original information back once you've given it away to the plaintiffs and you have that mass of recoded information. That is creating a new document. It is not just masking something.
But is it just making N1 in place of the name, is that creating a new document? You just had to do N1, N2, N3, just,
Yes.
you're saying that would be creating a new document?
It is, Your Honor. It is, and
Even if you consider that a form of redaction, though? Even if we're not talking about linkings, I think he's saying just as
I
that
understand.
form of redaction, you're saying that's a new document?
sure,
A new public record?
I think substituting one piece of information for another is the creation of a new document. And I think the cases under the Freedom of Information Act hold that repeatedly.
The cases all seem to be talking about doing a different manipulation of the data, coming up with, doing calculations that are not already being done. And here they don't seem to be asking you to do, they're just saying, well, substitute N1, N2, N3, and just give us whatever links you have.
I think, Your Honor, it's close to the Students Against Genocide case where they asked the State Department to alter its photographs that it had and put them at a new resolution so that it would not be obvious what kind of reconnaissance system made the original photographs. That's exactly what we're doing, or what they want us to do here. Change the resolution of our numbers so that they're different numbers and replace them and have a whole new set of...
Was that dismissed on like the equivalent of a 12B6, or what was the context of that?
I have to say I don't remember, Your Honor.
Well,
Just-
answer that question, though, for this case. I mean, there is a question of, are there other facts? Is this a 12B6 case, or is this a case where, you may have a great argument at summary judgment, depending on what the experts say and what links you find? Why is that not an appropriate way for us to resolve this, to say not on a 12B6?
I think, Your Honor, if it were only a question of how many documents had to be redacted and changed, or how difficult that would be a question of fact. I don't deny that for a minute. I think
Aren't the links a question of fact, though, based on your declaration that you don't know?
No, I do know about the items that they have requested. The declaration simply goes beyond that and says, I don't know in general.
You rely on the petition to say they request 46 things, and now you're relying on their reduction to 34. And that seems to me a little, doesn't link up. So if they're only requesting the 34 that don't have any links, why is there a problem? Why is your client not just producing everything that's there and saying, these things aren't linked, we're done?
We're not doing that simply because they've said that's not useful to them.
Right.
They don't want that. It's as simple as that. For 2 years, we have been debating this issue about whether we have to create links for them. We told them early on in December of 2000 that those links don't exist.
I'm just puzzled by, in the context of a 12B6, to say, it seems like if they ask for something, you give them what you have. And it's not part of the analysis, how useful will this be to them? They've asked for these documents. If it's an overly burdensome request, you go in and explain why you shouldn't have to do it. But for purposes of 12B6, you just say, this is what we have, this is what we will give you, as opposed to just, you have to dismiss their request altogether.
I think the point of law, Your Honor, that can be dismissed is their complaints request for linking documents where linkage doesn't exist.
Okay,
And
thank you.
thank you, Your Honor.
This one? Yeah. Go ahead. So yeah, I think that as a jumping off point, what facts, if we sent this back and said, no, not 12b6, try again in a motion for summary judgment, what facts need to be determined? That's my first question. And the second question is, I want you to weigh in on this idea that you've never wanted partial data because that doesn't do you any good, and that what their willingness has been up to this point to give you that. Those
Your
two.
Honor, I would point out that the Students Against Genocide case and all of the cases cited by my opponent in support of its position, including the FCC case and the Sander case of California, were all decided on motions for summary judgment after an evidentiary hearing or a bench trial. And that's because those courts recognize that there are a number of technical facts that need to be determined. One is...
Well, here, they told you there's 36 things that aren't linked.
So, Your Honor, with all due respect to the representations that Access has made on appeal here, the record doesn't reflect that there are no links to that data. In the appendix pages that my opponent cited, attorneys for Access stated in negotiations that those tables could not be released without the use of a unique identifier, and that consistent with Access' position that providing a unique identifier would require the creation of a protected unique identifier would require the creation of new records. Access stated in those appendix pages that they would have to create new ones after redacting the old ones, which is the position that we're combating here.
Okay, and then tell me about what facts you think would be needed.
So whether or what existing links do exist, the nature of them, whether our specific proposal based on the technical functionality of Access' database, and so far Access has declined to share any information about the database, any technical information about the database, but the court below should be able to decide whether our proposal would in fact, on those specific facts and the technical functionality of the database, only require the simple querying that we're suggesting is all that's required, and therefore not be the creation of a new record. And then we would also get into the very fact-specific issues of burden and risk of re-identification. And my clients have at all times been willing to continue to negotiate with Access, narrow its request. And in that vein, I'd just like to point out that...
Well, I don't want you to make any more points because you're answering my questions and you've been out of time since then, unless panel members have any additional questions for him. Okay, thank you.
Thank you, Your Honor.
Thank you both for your arguments. We'll take the matter under advisement and issue our decision in due course, and we will stand in recess to reset for our next argument.